Good afternoon, everybody. My name is Craig Vaughn. I'm the president of Castle, and welcome to Collections and Special Assessments during COVID-19. We're very excited to have you this afternoon. Quick story about Castle. Castle manages 300 associations in the state of Florida, and we just opened an office in Texas. We manage HOAs, condominiums, and apartments through 1,700 teammates out of approximately 7 different offices. I want to thank you for joining us this afternoon. Pretty certain when you signed up to be a board member, you didn't think you'd be doing it in the middle of a pandemic that none of us have ever seen. So thank you for getting involved and your leadership. Thank you for your thirst for information. We know you're investing your time this afternoon to talk to us about collections and special assessments. We have a couple of other topics that naturally roll into those discussions we're going to talk about this afternoon. We've received a number of questions from you in advance of our webinar this afternoon. So I've taken the liberty of grouping those into different discussion points. I'll ask Monique and Adam a bunch of questions that basically you have given me. If you have additional questions during the webinar, please use the Q&A function that Shauna described to you in the introduction to submit your questions. We'll watch for those as they come up, and I'll feed them into the conversation to the extent we can, and we have some time at the end to answer some specific questions. One of the things I will want you to know up front is we acknowledge that, as board members, you're not experts and you're not expected to be experts. You're actually protected in most circumstances if you exercise the reasonable business judgment rule, and Adam and Monique will talk about that later in terms of how you can protect yourselves. Before I ask them to introduce themselves and their firm, I want to remind you that we're having a discussion this afternoon, a conversation. Adam and Monique are not intending to provide specific legal advice for your association. We would encourage you to seek out your professionals, your management company, your legal expertise, your legal experts, and your other professionals to talk about these items that are specific to your association. So with that, Monique, I'll start with you. Can you introduce yourself and talk a little bit about the firm?
Sure. Good afternoon, everybody. My name is Monique Parker. I'm one of the founding partners of the law firm Rabin Parker, Gurley, PA. We've been conducting business in the state of Florida for several years now. Our firm specializes in community association law, and that is actually all we do. We don't practice any other type of law. We represent homeowners associations, condominium associations, and cooperative associations all throughout the state. We have 3 offices. One is in Lakewood Ranch. Our primary and original office is in Clearwater. And we just opened a 3rd office up in the Hillsborough, Pasco County area as well to serve clients in the northern part. But now that we're all remote, we're pretty much working everywhere in the state and enjoying doing so, even though it's a little bit of a new technology press. It's going so far so good. Adam?
Thank you, Monique, and I want to thank Craig and Castle Group for inviting us to participate here this afternoon, and thanks to everybody for joining us. Again, my name's Adam Gurley. I'm one of the partners of the firm. I primarily focus in representing community associations in connection with litigation. So I often joke with our clients that I hope they don't have to work with me a whole lot, because if they do, then things have maybe gone south a little bit for one reason or another. But I primarily handle everything from enforcement disputes to foreclosure litigation to construction defect litigation and any other litigation that community associations may find themselves involved in. The only other thing I'll note is that our office recently started a blog where we're addressing some emotional support animal issues. We know that's a hot topic right now. Putting on some webinars of our own while we're dealing with this COVID, some virtual presentations dealing with support animals and some changes in the law there. So if you're interested in some of that material, you can find it at rpglaw.com. So thank you, Craig.
That's excellent. That is a hot topic for sure, given the sensitivity of what's going on. Just before we kind of jump into a quick review of the agenda, I wanted to advise everyone that we are using a Zoom platform today. We checked Zoom's performance just to make sure everything's fine. They are very busy, obviously, with what's going on. So if we have a particular problem, during the webinar when we freeze up. We will work it from our end. If it's your computer at your end, my advice and the advice I get from our IT team all the time is, turn your computer off and on. It's the simplest answer. We paid them a lot of money to tell us that. So, but it is good guidance. Listen, today we are going to talk about kind of 6 topics, if you will. If you could move to the agenda, where we are. So I want to just touch base, get Monique to touch base on where we are. We're going to talk about collections, which we advertise. We're going to talk about kind of cash reserves, sources of funds in this situation, and then on to special assessments and their relevance to that solution and what we can do in this time. Talk a little bit about meetings, a little bit about liability and insurance. We talked about the business judgment rule I did in my introductory comments, so we'll touch on that. And then any other questions that you may have. Our scheduled time is an hour, and if we're done early, we're done early. If not, I think we have a full agenda, but we'll respect your time as we get towards the end. What I'd like to start with is where we are. So we are faced with executive orders, we are faced with municipal orders, we are faced with county orders. So what I would ask you, Monique, if you can you give us a kind of summary of where we stand today relative to the guidance from those governmental authorities?
Absolutely. I'm going to stick primarily with the governor's orders, with the exception of one that I'll highlight as well. But to get into the individual county orders, we would be here long beyond the hour allocated. So we'll go with the primary ones. There have been many since March when all of this began, but I'm only going to really highlight the ones that have the most direct impact on community associations. The first, of course, being Executive Order 2020-52. And that was the governor's order that actually declared the state of emergency that we're currently in. And that order is effective presently through May 8th unless it's extended. Following that, one of the first ones that came out was Order 2020-68, and that referenced the closure of bars, restaurants, and the beaches. That is also, well, actually originally it was through the middle of April, but that has been extended to May 8th as well. So we're not going to see our beaches open anytime in the very near future. Executive Order 2020-69, that related to public meetings. And while that public meeting order only related to government entities, it really did give some guidance as to associations, because even though you're not a governmental entity, you still have to deal with your own meetings, and we'll talk more about that. That order that basically suspends public meetings is also in place through May 8th. In fact, almost all of these are, except for the next 2 that I'm going to mention. So the next one that came out was Order 2020-82, and that related to isolation of individuals traveling from high-risk areas, New York, California, anywhere outside of the United States. And that order is the one that mandates that individuals self-isolate or self-quarantine themselves for 14 days upon entering the state of Florida. And a lot of associations have had concerns about that order when their residents are coming back or guests and visitors are coming to their various community associations. Again, that order will come into play a little bit later when we start talking about visitors and guests. Vacation rentals followed on the heels of that one. That's Order 2020-87, and that basically prohibited vacation rentals until April 30th, and that has not been extended as of yet. It may, but essentially you are not permitted to rent out your condominium units for periods of less than 30 days to, we'll call them transient occupants. And as I said, that order is in effect till April 30th, but we reasonably expect that one's going to be extended at least until May 8th, if not possibly longer. Then the big one, the one that everybody is essentially familiar with, it is Executive Order 2020-91, and that is what we reference as the stay-at-home order. That's the order that basically said you need to stay at home unless you're seeking out essential services or performing essential activities. If we have questions about what constitutes essential services and activities later, don't hesitate to ask them. I won't go into detail, but suffice it to say, I think most people know medical services, groceries, things of that nature are essential, and just about everything else is not. That order right now is actually still in effect only through April 30th and has not been extended to the May 8th deadline. although it may possibly happen. And then last but not least, as far as the governor's orders, we also have Order 2020-94, and that order suspends mortgage foreclosures throughout the state. Now, the interesting thing about that order is many of our client associations have tried to contact us to determine whether or not that impacts their assessment foreclosures. And it does not, but we'll let Adam touch base on that a little bit more later when we get into that subject matter. That order actually is in place through May 17th. And then the final order that I want to mention is not an executive order at all, but it's an order that was issued from the Department of Business and Professional Regulation. And that order number is 2020-04, if you're going to try to look that up. There is some question among the legal professionals in our field as to whether or not this order would actually be upheld if challenged. But at the moment, we are operating under it, and it was our opinion that what the order does was essentially going to be upheld by courts anyways. And what happened is the division, the DBPR, actually came down and said, okay, the emergency powers laws that are found under the Condominium Act, the Homeowners Association Act, and the Cooperative Acts, which we will talk about probably next, are effective during the declared state of emergency through May 8th. So we'll call it opining, we were giving our clients the opinion that those emergency powers came into play even before that order was issued. But when it was issued, it kind of gave a little more credibility to the position that we and other legal practitioners were taking as it related to those emergency powers and how they impact the various associations. So those are the relevant orders that most directly impact your communities. There are several more, but I think that's beyond the scope of our presentation today.
Monique, that's a great summary. Thank you very much. Your comment on the forbearance of mortgages is directly related to the collection discussion we're going to have, and there's no such requirement of associations, I think you said. So that is good news. I would like you to comment. You talked a little bit there about the emergency powers and the state of emergency, which triggered emergency powers under the various statutes. Can you comment on what that gives the boards and associations the right to do, and also maybe what it doesn't give them the right to do? I know some of our associations have some confusion about what exactly they can and can't do.
Right. So the emergency powers provisions are located in all three acts, as I mentioned, condominium, cooperative, and homeowners associations, and they are nearly identical. And if you are taking notes, I can tell you the sections that we're referring to are 718.1265 in the Condominium Act, 720.316 in the Homeowners Association Act, and 719.128 in the Cooperative Act. And basically what these provisions say is that unless it's directly prohibited by your declaration or your governing documents, that the association can take certain actions that you wouldn't ordinarily be permitted to do under the law during a declared state of emergency. So again, right now, these powers only extend through May 8th. What those would include are the ability to conduct board and membership meetings with notice requirements that are practical under the circumstances. So if you can't give a 14-day notice for a membership meeting for certain reasons, or if you have to give them by a different manner, electronically, when you maybe don't have the consents in writing, then you're allowed to give notice as deemed practical under the circumstances. Of course, it gives you the authority to cancel and reschedule any of your meetings without having to worry too much about notices related to that. You can implement a disaster plan. Now, that's one of the provisions of the statute that we've relied on for many of our associations who are trying to determine what they need to do to maintain and sanitize their common elements and to maybe declare things off limits. So the disaster plan part of it is quite a bit. The statute also says that the board has the authority to determine portions of the common elements that maybe are not safe for access or occupancy by individuals. And those are the provisions that come into play when we talk about closing your amenities, such as your pool and your rec facilities and your gym areas. So that's a big part of the statute. Another big part of it that is important and especially relevant to today's topic of discussion is the ability to obtain funding in the form of a loan or line of credit without membership approval, even if your governing documents otherwise require membership approval. There are some limitations on that, and we'll get to those in a minute. But also as it relates to special assessments, many governing documents, bylaws, or declarations will require membership approval for special assessments. But under the Emergency Powers Act, the membership approval requirement for special assessments is actually suspended. So you don't need to obtain membership approval to do that. And then last but not least, it gives a pretty broad power to mitigate further damage. Now, how attorneys are interpreting that is different. But if there's something unique to your individual community that you might need assistance with, your legal professionals may be able to help you craft something under that authority to mitigate further damage. And of course, mitigating further damage would mean preventing harm or illness to your residents. So those are the main functions of the emergency powers that you have. Now, as it relates to limitations, we just spoke about the first one. If there's something in your declaration that specifically prohibits you from taking some of these actions, you would need to be concerned with that. And so you'd want to talk to your counsel to be sure. Another limitation, especially as it relates to funding and today's conversation, is that if you're borrowing money under these provisions, you have to be borrowing money for one of two reasons. One is to actually repair damages. Now, you're not really going to have any damages to your property like you would in a hurricane situation, so that part of it isn't necessarily going to apply. But the second part does allow you to obtain a loan to address a shortfall, provided that the shortfall in funding, or the money that you're going to use it for, is to carry out the duties of the association when your operating funds aren't sufficient. So it's the duties of the association during the COVID response that are actually going to empower you to obtain that funding. It's not an ability to go ahead and get funding in order to repaint your buildings in 2 years without having to get membership approval. So it has to be relevant to the issue at hand, to the COVID-19 response, in order to trigger that provision. But as long as that's what you're using it for, then you can go ahead and do that. It does not give you power to use reserves without a membership vote, and I believe that's a topic of conversation for a little bit later as well, so I won't go into detail. But then last but not least, again, of course, the limitation is that it's only effective during the declared state of emergency. So everything that we're talking about right now, you only have these powers until May 8th unless the declared state of emergency is extended.
So what I hear for everybody listening in is a quagmire of regulation and rules, and I think this is a made-for-your-attorney program. But I would highly recommend, exactly as you say, don't do this alone as a board member, and involve your counsel, help you navigate the waters here. And I think when we talk about the business judgment rule, you would be expected in reasonable business judgment to use your attorney to guide you through, and absurdly that provides you a bunch of protection later, I think. Let's get into collections, because I think that's important. We talked about the emergency powers. The big issue on everybody's mind is the payment of April maintenance. I will tell you, from Castle's standpoint, we ran our delinquency report, our AR, across all the associations we manage on January 23rd, which is the last full quarterly cycle before the crisis, and April 23rd. And the total receivables were almost identical, which is great news for associations, especially those that collect their maintenance quarterly. It gives you a little bit of time. From a monthly standpoint, we really weren't into the full depth of the layoffs and all of those types of things. So you need to be more aware about what's going on in May, and we're going to talk a little bit about that later. But from Castle's standpoint, we're viewing collections as business as normal. And Monique, I would ask you, what guidance are you giving your clients relative to collection of April maintenance?
Exactly the same, Craig. We've advised all of our clients that they need to continue with collections in the same manner that they always would. While it is admirable and nice to try to make different concessions for collection, the time is not right to be doing that, and it could have a very bad detrimental effect on the association long term. So really you need to stay the course, keep things moving forward in the way that you ordinarily would, and hope for the best. That being said, of course, there are some roadblocks that you may have as it relates to the courts, and Adam will get into that a little bit. But when it comes to collection in general, I think the important thing to understand is that you need to collect uniformly and consistently against all your owners. The board has an absolute fiduciary obligation to do that. If you don't, then you put your entire membership at risk for special assessments and problems. But that doesn't mean that you can't still work with individual owners on a case-by-case basis that may have a problem. And that's no different than any other time of the year. If we were having this conversation last year at the same time, nobody knew about COVID, nobody had any suspicion that something crazy like this was going to happen, I'd be having almost the exact same conversation that, look, you need to be uniform, you need to be consistent, but that doesn't mean you have to be heartless. If somebody truly has a hardship and they're doing the best that they can, then on an individual case-by-case basis, you have the ability as an association to work with those owners.
I think that's a great point, and I would add to kind of our strategy is we understand people have been affected differently by this. People have been affected financially, and I think your guidance to the boards on a case-by-case basis. Adam, let me ask you. Some of our webinar participants are asking about the late letter process. I think Monique talked about that. But what about waiving of late fees and making special accommodations and people facing a financial hardship? How do you make sure everybody is treated equally? How would you recommend an association deal with, a process to have those challenges bubble up?
Well, I think, as you said, Craig, the phrase of the day is business as usual in terms of at least the initial collection process, the initial notice for collection. It sends your letters as you would in your normal course, because of course, the goal for the association is not just to make it through this COVID-19 pandemic relatively unscathed, but it's to make sure you're in a position at the end of this thing, when it does in fact come to an end, to resume normal business and make sure that the association's accounts are where they need to be, so the association's in a position to operate business as usual. Again, throughout the course of this whole thing, but particularly that the board puts the association in a good position at the end here. And in fact, that we'll talk about fiduciary duty a bit more later, but that falls right in line with the board's fiduciary duty to make sure that we're putting the association in a good position now and on the back end of this thing. So it's business as usual as far as proceeding with the collections process. When we talk about the waiver of fees, we'll call them, well, we know we can't waive assessments, right? That's not on the table at all. Waiving late fees, as Monique said, we can look at it on a case-by-case basis. On the other hand, it's a little bit of a slippery slope if you do for one and not the other. So there has to be some kind of circumstance there that allows for a unique review of one where you're not going to offer the same to the other. And I would suggest that distinction can become a little blurred and get associations into trouble. And so I think the takeaway for me is that the most well-intentions on behalf of the board in terms of actions and trying to be sympathetic to the members, while completely, understandable, those best intentions might end up really hamstringing the association in the long run. And the association might have an issue with its own accounts and paying its bills. So again, I go back to business as usual. Of course, there can be exceptions on a case-by-case basis. And as we talk more about fiduciary duty and the board's ability to make some distinctions on a case-by-case basis, we get back to consulting with experts and looking at these things on a case-by-case basis, protecting the board. Ben Raven, one of the other partners of our firm, his favorite phrase is protecting the innocent. And the innocent to us are the volunteer board members who have volunteered their time to make sure their community is well run and property values are kept up. And the best way to protect the innocent when making these decisions is, again, to look at it case by case and to consult with your licensed community association managers, your accountants, and your legal counsel when making these decisions as far as waiver of late fees, but also as far as how aggressively your community is going to pursue the collection of assessments and past due assessments as this COVID-19 pandemic strings along here.
I think that's great guidance, and it's kind of what we're advocating as well, is again case by case basis. But if I understand you correctly, business as usual means kind of send your late letters, you charge your late fees, you deal with the exceptions. But you go ahead. No one's advocating for kicking someone out of their house. I don't think that's where we're at now in terms of foreclosures. But there is a series of steps before that happens. You know, the association sends a demand. It could file a lien. Are the courts open? Like, is that process been interrupted?
Well, and so that's the practical side of this. So we would say send your pre-lien notice, get your lien in place, and even file the lawsuit, again, subject to that case-by-case analysis, but file the lawsuit. The courts are accepting the filings of these lawsuits. So now let's get into the practical. Well, the practical is the courts are, I'm going to say, all but shut down for a lot of these cases. Judges are still conducting hearings on some very preliminary issues, and these hearings are all by phone. But in large part, summary judgment hearings have been canceled. Courts are postponing foreclosure sales, foreclosure hearings. So the practical, again, is getting in front of a judge and actually pushing these things along. We're not really seeing it right now. The judges are reluctant to kick someone out of their home, for better or worse, right or wrong, understandable in a lot of circumstances. So they're taking this on a case-by-case basis as well. And another theme for today, I think, is we're in unprecedented times. Everybody's kind of trying to navigate this new issue, and judges are no exception. So they're erring on the side of caution and not kicking people out of their homes and not moving these things through too quickly in the midst of all of this. And so things are moving pretty slowly. We had a phone hearing recently, it was about 2 weeks ago, on a motion for summary judgment, and the defendant was pro se. And the defendant sent in a 2-sentence letter to the judge that said, "Judge, I need to postpone the hearing because of COVID-19. And the judge issued an order that same day that said, "Okay, hearing's canceled indefinitely." Well, it was a phone hearing, so we were very confused as to why COVID-19 prevented that participation. But nonetheless, you can see just how far the judges are looking at this and saying, you know what, any questionable call, any gray area, we're kicking the can down the road, and we'll revisit these foreclosure proceedings once this all comes to an end. And so again, I think we get back to boards should put themselves in the best position they can by going through the pre-lien process, the lien process, up and through filing the foreclosure suit, again, subject to that case-by-case discussion. And so even if the courts are essentially shut down and not setting these things for sale, not scheduling hearings, at least when this all comes to an end, we're at the ready to go ahead and move forward with that final step and make sure that the association's recovering the funds they need to recover from this whole ordeal.
I think that's I think that's great guidance, and that it's going to end hopefully sooner than later. We're all praying, and when it ends, just be in a position to protect yourself. You know, you've got your I guess your fiduciary obligation is to protect the association. So I appreciate that. Listen, we did have a specific question about my amenities are closed, I don't want to pay, or I want a reduction in my maintenance fees. What have you heard it? 1 and 2, what guidance are you giving your associations around the answer to I don't want to pay my maintenance because the amenities aren't open?
Yeah, we've heard that now, Craig, and we've heard that for the many years we've been practicing this outside of COVID. There's damage to the pool, and they brought in contractors to fix the pool. The next thing you know, an owner's saying, "I'm not paying my assessments until I can use the pool again. What am I paying for?" And the case law one on that is very clear. Again, non-COVID related, but the case law is very clear that an owner's obligation to pay assessments exists, regardless as to whether there's some lack of access to the accommodations on the property. They still have to pay assessments, and that absolutely applies here. I get the common sense logic of the owners to some degree when they raise that issue. But I think the bigger point here for the association is, one, the pools are closed and the amenities are closed at no fault to the association. It's not like the board is any more pleased with the circumstance than the owners. And meanwhile, the costs associated with maintaining and operating those accommodations, it isn't going away. You still have to pay for your air conditioning for the clubhouse and pay to put chemicals in the pool and all of those improvements and maintenance responsibilities that cost money. And so if owners were let off the hook because the accommodations were no longer usable or accessible, a lot of associations would crumble. Those funds have to come in to keep those amenities alive. So long story short is that argument or that claim or that position does not hold any weight in the court system.
So it's an emotional one, but not a practical one.
Exactly right.
Yeah, I think we're seeing the same thing. You're also incurring expenses you wouldn't have otherwise anticipated you would incur. You have extra cleaning, you have some very specific, protocols that are being put in place. So it's really like any other budget variance, right? You budget something, you have those expenses. Sometimes they're different. You evaluate it next year when you do the budget. That's kind of what we're advocating for our firms.
Right.
So guys, that's lots on collections. Let's pivot to for a second to cash. And ultimately, if you collect your money, you have the cash to pay your expenses. You don't really have a need for financing for those types of things. So we didn't see a big burp in April. We expect to see a little bit of a bigger challenge in May with monthly maintenance payers, because we are in the middle now of 22 million unemployed and a backlog of unemployment claims and these types of things. So we're being asked from a cash flow standpoint, what options do I have? So what we're advising our treasurers out there, and I'm a CPA, so I'm kind of living that dream with you, but it was basically take a deep breath and take stock of where you are. Most associations are well financed. If they follow the general guidelines in our industry, they've kind of got 1 to 3 months of maintenance expenses or expenses in their operating cash, so they can weather a bit of a storm. So, don't panic. You do have some options. One of which I want to talk about first, Monique, is, I'm a little tight on my operating cash. I have a bunch of reserve money that I put away for a rainy day to do these projects, to pave the roads. I would ask, can I utilize the reserve funds, and what rules do I need to follow? I think you said earlier the emergency powers do not give me the right to use reserves, but can you comment on how I can access them as an association?
Sure. So generally speaking, the law says that reserves are only to be used for the purpose that they've been reserved for. So if you have pool reserves, you can only use them for the pool. If you have roof reserves, you can only use it for the roof, unless the membership approves otherwise. And that does not change under the emergency powers. Now, for a second, I'm going to say set aside HOAs. So if you're an HOA board representative listening to this presentation, I'll get to you in a minute. Cooperatives and condominiums are more restrictive. Their reserve funds absolutely cannot be used for a different purpose without a membership vote. And the membership vote that is required is a majority of your quorum. So you call a meeting together, a membership meeting, and we'll get to that later too. But you'd have to have a membership meeting. You have to give your owners an opportunity to vote. And as long as you have a quorum or more that participate, you need a majority of those members that are casting votes to vote in favor of your use of reserves. And then if they approve it, you can certainly use those reserves to fund a shortfall. Understand there's no such thing as borrowing from reserves. We get that question a lot, where an association will say, well, we're just going to borrow. We're going to borrow the money from reserves. We're going to pay it back. We're going to get a loan to pay it back, or whatever we're going to do. Doesn't matter. It still falls under the same thing. You have to get membership approval to use those reserves for any other purpose, no matter what you call it. Now, in a homeowners association, it is slightly different, because in a homeowners association, only certain types of reserve accounts are restricted in the same manner as the condominium. And those reserve accounts are those that were either initially set up by the developer or otherwise required by your governing documents. So if you have something in your declaration or bylaws that says you will have a reserve account for paving or whatever your needs might be under your documents, that would be a restricted account. And then last but not least, if your membership voted to implement and approved a reserve account in the past, that reserve account would then be restricted. We call those statutory reserves. But if you're an HOA and your board just decided wisely one day to set up a reserve account for certain types of expenditures, and it was not required by your governing documents, not established by the developer, and not voted on by the membership, then HOAs, you can use those reserves for really whatever you want. It's more like a savings account that you established, and it's not restricted.
So I guess that, so maybe would be the answer to that question. Can I use the reserves?
Exactly. So yes
that's
and no is the answer. Yes and no.
That's why we have attorneys and CPAs. So I would encourage you, if you haven't got your 1 to 3 months, or you're worried and you have some reserve money, go talk to your attorney and CPA to make sure. Listen, it's there. There is a mechanism to use it, but you got to go through the steps, right? I think that's probably a fair summary. We do have some boards asking us, and I'm sure your clients are as well. Listen, reserves were to fund money for long-term projects, and we're really thinking about the short term right now. Can I waive my funding of reserves for the next 3 months? And then how, if I want to roll that through to the owners, how do I do that? So what would your advice be in that regard?
Well, the same thing. You can only waive funding with a membership vote, same as using. So if you want to waive the funding of your reserves for a certain period of time, you're going to have to put that to a membership vote, subject to exactly what we just spoke of. It's really no different than using reserves for a different purpose. Right. So the only thing, the only caveat, and this actually would apply to using it for a different purpose as well, is on that membership vote, I forgot to mention earlier, there is specific language you have to include on the proxy to your owners, basically advising that waiving reserves in whole or in part or using them for other purposes could result in a shortfall requiring a special assessment in the future. So we get back to the very same thing. Yes, you can waive reserves, but there are specific steps you have to follow to do so. So I would say definitely consult your counsel if that's one of the avenues that you want to take. Okay,
good. Thank you. Let's move on to loans for a second. You talk about emergency powers and the ability of a board to borrow money. They have to have the loan in place by the 8th of May to exercise emergency powers, or how does the deadline work? And I'm throwing you a bit of a curveball. We didn't talk about this, but I'm curious.
You know, that's a really great question. I would argue that they don't have to necessarily have the loan in place, but I think that the board will have had to have a meeting and make a formal decision that the loan is necessary and decide to go forward with it, and probably at least have the process underway with the application being in place and everything prior to that May 8th deadline. If it doesn't fund by then, you know, we could argue that that's, you know, still fine, that they don't need to get a membership vote just because it hasn't funded. But again, we get back to that same caveat that it's going to have to be used for a purpose that is, you know, relevant to the shortfall in the COVID situation. So it's a touchy situation to be able to do it without membership approval under the emergency powers. But it certainly can be done. And that really is a good question, Craig. I don't have a clear answer for that other than my opinion.
Which is all we're
I will
asking
say
for.
one other.
Yep. Sorry,
I'm sorry. I just want to say. Go ahead, Craig.
No, you finish. There's a bit of a delay on my end.
We talked about the emergency powers and the limitations on that in order to be able to obtain a loan without a membership vote. But don't forget, the governing documents for every association are different. And frequently when I amend governing documents for associations, I actually give the board authority to obtain a loan up to certain amounts without membership approval. So you might not even need to use those emergency powers with those limitations if the governing documents of the association allow your board to get a loan or other line of credit without membership approval as well. So don't forget to look at your governing documents. Don't assume that you have to move forward under the emergency powers. You might have some authority in your governing documents already.
That's great. That is great guidance. And that's exactly what we've seen as well. To talk about loans just for a second, I just wanted to touch on, you know, the stimulus package, and there is lots of dialogue around whether associations are or are not qualified. There's two relevant loans in the program. One is the PPP, the Payroll Protection Program. That's the one that ran out of money. I think it's now been, I'm not sure if it's all final, but I think it is final, Adam. They've approved the the new legislation package?
It went to President Trump today, so I don't know if it's been signed as of this conversation, but I expect by the end of the day it'll be all systems go.
Well, that'll restock that program. There is some question of whether or not associations are actually eligible for that program. And Adam, we're hearing lots of stuff. What are you advising your clients relative to their ability to qualify for the payroll protection plan loans?
To this point, it's our understanding that the SBA has been pretty clear in saying that community associations are not a qualifying business. So far, they've only accepted the 501c3 not-for-profit businesses and stated that those are the only ones that can qualify for the PPP loan. Now, a lot of legal practitioners in the state of Florida, there's a blog amongst attorneys, and they share emails about various things going on. As I'm sure you can imagine, COVID-19 is the hot topic right now in the PPP loans. And there's a lot of, I'll say confusion, but a lot of disagreeing with that decision that the SBA has put out as far as associations and their ability to qualify. The associations are assigned an NAICS number, which is a North American Industry Classification Code for various industries. For anybody particularly bored who wants to look it up, we're 813990. But so we're a business, and we're an industry with the business as classified under that code. So I'm certainly of the opinion that as legislation is written, community associations should be included, but they're not, and nobody comes to me for those decisions from the SBA. So for now, there is no qualification. If that changes, the qualification to obtain a PPP loan, even for community associations, the association will have to actually have employees on staff for the association. So if you work through your management company and you're looking at Castle Group's employees, those are Castle Group's employees, not the association. So even if something changes and it's extended to community associations, it will be extended only to associations with direct employees on the payroll. Now, for my pessimistic take here, or takeaway, I guess, the way the first round went, they've re-upped it, I think, 310 billion now. The first 390 billion went away in something like a week and a half or less. So I think by the time there's any change in position here, no matter how hard anybody's lobbying the legislator, I think that money's going to be long gone before anybody makes a change on whether associations are able to secure that loan. So I think PPP is all but out at this point for associations.
Yeah, we're seeing the same thing. And I think we do get some boards asking us, and I would also urge them to read the representations they have to make in the application process, because one of the things we're hearing a lot about is chasing down people who applied for loans, made representations that might not have applied to their businesses. And I think there's going to be a big investment in what's right and what's fair coming our way. So I would urge our boards to look at that. The other thing, there are the EIDL loans, the economic injury loans. They're referred to as EIDL. We do see that they're eligible. Associations are eligible for those loans. They're up to $2 million. They have a great interest rate. You must apply by December 31st. You have to show economic loss. So the reality is this need for loans, this need for borrowing is really coming if your owners don't pay. So we don't know right now whether the owners didn't pay. So our thinking is it's a little early on the EIDL side. Would you agree? And do you agree that associations are ultimately going to be eligible for those loans?
It's our understanding that associations are eligible for those loans, and I'd agree on the wait and see if that's something, a level of funding your association will need if the payment of assessments really drops off. And if that becomes the case, then the name of the game is moving pretty quickly. If your community or your board is starting to see the accounts drain a bit and think you might need to head down that road, that's where your association and your board is greatly benefited by a strong management company like Castle, not only when it comes to the documentation that you need to get those loans through, but the relationships with the lenders right now. There are so many small businesses that are trying to secure loans through the SBA. And so those lender relationships and the help in getting that documentation, getting those applications rolling with your management company is really imperative.
Well, teed me up very nicely. Thank you. What we're really advocating for our associations is to arrange with your current banking partner an emergency line of credit.
Yep.
We have lots of great banks that are in our landscape that understand loans. They understand the circumstance. We're calling it kind of cash flow insurance, if you will. So if it's looking like you have a need and you work with your management company to determine, you might get with your local lender, your local banking partner, and arrange an emergency line of credit. And your management company, we're doing lots right now for our associations. Your management company should be there for you to provide all that data. All you kind of have to do is understand the need. So that is kind of where we're recommending with respect to that. Monique, if we are going to borrow an emergency line of credit from our bank, what would they normally be looking for in terms of security?
Well, the primary source of security for lines of credit or loans for a community association is a special assessment. And that's actually where the emergency powers provision allowing special assessments without a membership vote may be helpful, because to specially assess your members just to cover your shortfall is a bit of a circular problem, because if they're not paying their regular assessments and that's causing a shortfall, well, then a special assessment isn't going to cure that, because they're clearly not going to pay the special assessment. But you can impose a special assessment that's to be paid a few months down the road by your members, that serves as collateral and security for an immediate line of credit to assist the association to get through this time period. Just remember, though, one, check your governing documents. If you don't need a membership vote, that's great, because then you can use your line of credit just about for anything you want. If you do need a membership vote and you're going under the Emergency Powers Act to avoid a membership vote either for the loan or for the special assessment, make sure that you're being very careful about the use of those funds, because it's only permitted if you're using it to address COVID-related issues and a shortfall that's resulting from the COVID-related issues.
So
there really aren't any other sources of collateral that are readily available. You cannot use reserves under any circumstances, because technically reserves are not the association's property. It belongs to all of the members. So your reserves cannot be used to collateralize a loan. Sometimes you can use real property, such as your common elements recreational area, as collateral, but you really need to consult your documents to your legal counsel to find out if you're permitted to do that as a community association. So those are a little bit more remote, not as common. The number one common form of security are special assessments.
I think that's great. We do get a lot of, well, I have reserve funds, can I use them to secure a loan? That's great. That's a great subtle explanation that you can't. Thank you. So now I want to borrow money. I'm practicing social distancing. My community's closed. I need to have a meeting. So let me pivot into meetings for a second. We're setting up a bunch of Zoom meetings for our boards right now, but should we have board meetings? Would be the first question, and then I'll pivot on to kind of a more general annual meeting. But talk to me about what advice you're giving your associations relative to board meetings, and can I have them?
Sure. Absolutely, you can have them under the emergency powers provision, and you should have them. But in our opinion, we're recommending that all of our boards not just practice social distancing, but actually handle these meetings remotely, as you said, via Zoom or even just a regular conference call. You don't actually need to have video conferencing to conduct your board meetings. And in fact, even absent an emergency, the various acts do allow for board member participation in a board meeting by phone. So you're already halfway there. So your boards are able to come together under the emergency powers, conduct their meetings by phone. And we do think it's important for the boards to meet periodically, because as we said, these are unprecedented times. When you signed up to be a board member, you probably weren't expecting this. So it's important for you to make sure that everybody on your board is on the same page, and that you are acting responsibly under the circumstances to address the needs of your community in an unusual, the face of a very unusual circumstance. So having the meetings is very important.
And if I can't have a meeting, can you just talk to me for a second about the concept of consent and approving a resolution by unanimous consent?
Sure. It doesn't even have to really be unanimous, but you're assuming that you're taking action that the board is authorized to take either under your documents or under the emergency powers. Then board members that are unable to attend a meeting, whether by phone or otherwise, can always consent in writing to the action that's being taken by the board. They can consent at the time, they can consent before, they can even consent after the fact. So there's a lot of ways that you can get work done properly, even in the face of these very difficult circumstances.
Excellent, thank you. And then just for a second, annual meetings, I have my annual meeting. It was scheduled for May 15th. I've sent my first notice out. I'm a condo. Can we, and maybe condos and HOA separate, can we cancel our annual meeting? Should we postpone? What is your guidance to your clients?
Sure. So the easy answer is yes, you can. The emergency powers clearly says you can cancel any meetings, and that would include your annual meeting and your election. So yes, you can. Should you postpone really is going to relate to the temperament of your community. So I'll tell you how we've advised our clients. It really relates to, is anybody else running for the board? Is the same board going to stay in place? If so, then cancel the meeting. There's really not going to be any harm in not doing it. If it's a contested election, well, then we might advise our client to go forward with the meeting, because what you don't want to do is create any more turmoil than we're already having to deal with under the circumstances. So if it was coming into an issue where there's a lot of controversy and a lot of problems already going on, canceling that annual meeting might just make matters worse and cause more disruption in the community than you already have. So whether or not they should hold their annual meeting and or an election really is a factual case-by-case basis that the board has to make based on its best guess. You really need to consider the needs of your community. And remember that fiduciary duty. It comes into play here too. Your duty as a board is always to do what is in the best interest of your community as a whole. And if you can confidently say, without self-dealing or thinking about your own interests, that canceling the meeting is in the best interest, then by all means do so. If your gut tells you, on the other hand, that no, we really should have this meeting, our members need it, then you should have it. Again, by remote means, though. We shouldn't be having meetings in person where we're getting groups of people together.
I can already hear the argument. You canceled the election because you wanted to stay on the board.
Exactly.
I'm sure that's coming at us sometime in the summer, I would hope.
Right. And that is the problem, because if you cancel the meeting, especially in the condominium avenue, so HOAs, it's a little more lenient most of the time in an HOA, but in the condominium context, if you cancel your annual meeting and election, you got to begin that entire notice process again after the state of emergency is lifted. So for those associations that maybe have an annual meeting coming up in another week or two, now you cancel that, you're going to be waiting not only till the state of emergency is lifted, which is the earliest, May 8th. It could be extended. If that occurs, then you're going to have to start your entire notice process over after the emergency period is lifted. So that could be pushing it way out towards the end of this year, depending on how things progress.
Well, it's interesting. We have a great question, and my meeting is postponed. I'm having an election. What do I do if the ballots are sealed or sent in? I'm just waiting for my meeting. What can I do with the ballots? Can I postpone the meeting? Do I need to? How do I have to not start the process over?
Yeah, we've had a lot of clients, and we're trying to be creative with them. For those clients that are deciding to move forward with an election, and I know this gets a little complicated, but understand that the election is actually different than the meeting.
Right.
The election actually takes place at the meeting, but it is not, in fact, the meeting. So you could actually have an election without having an annual meeting, and you can have an annual meeting without an election. But for those associations that are going to have their election, especially in the condominium context where you have the inner and outer balloting system that you have to be aware of, what we've generally counseled is to have maybe 2 people with social distancing that would otherwise be able to count the ballots, maybe a manager there and somebody that is a disinterested member. Do so under the normal means that you would count ballots, but with a video actually recording the process. Mm-hmm. So rather than your members being able to be there and to observe the election taking place as they ordinarily would, you would either have a live video feed of the process going on or a recording that's available in the event the election is later challenged. so that they can actually see everything that happened. And you can do that with social distancing of 2 people. You can really even do it with 1 person if that's what the board prefers. That's where the emergency powers provision comes in as well, because the various acts allow you to take measures that are appropriate under the circumstances to still conduct business and to have your elections without having to satisfy the normal notice requirements and open meeting requirements that you would otherwise have.
So all is not lost. There's an opportunity. So I would suggest the participant who sent in that question, you can keep going, but get with your attorney to make sure you get the appropriate guidance. You know, you talked, Monique, about doing the right thing as a board, having your election if it's contentious. You know, we don't expect our board members to be experts, which we talked about early on. You know, board members are volunteers. I mentioned the concept of reasonable business judgment. And Adam, I'm going to ask you, as a board member, how does that help me? And what do I need to do to be protected by that rule?
Yeah, and the business judgment doctrine, or the business judgment rule, it's a board member's best friend. And as an attorney who litigates defending boards, it's my best friend. And the business judgment rule is really, again, intended to protect volunteer board members. There's some recognition, again, that you're volunteers, you're not presumed to be experts, and this is the doctrine that serves to protect you. And frankly, it protects the board in their decisions. It protects the board if the board makes what most would consider to be a bad decision, so long as the board acted reasonably when investigating the issue, they conducted due diligence when reaching that decision. And so there's a presumption of reasonableness where the board and the individual directors have consulted with and relied upon the advice of experts. So experts are really the name of the game. And we get back to that phrase I used earlier that I steal from Ben Rabin in our office, and that's protect the innocent. Well, how do we protect the board, the innocent? We tell you to consult with legal experts, to consult with accounting experts, to consult with your licensed community association managers. And if you take all of that information and all those consultations and you make what is perhaps a bad decision, you're still generally protected because it'll be deemed reasonable because you relied upon experts. And I had a case recently up in Pasco County Circuit Court where a board's budget was adopted, and the expert on the other side said pretty clearly that it was an accountant, and he said this budget is inflated to kingdom come. I mean, I can't even reconcile these numbers. And we marched into court and said, well, our accountant said it was fine, and the Department of Business and Professional Regulation said it was fine. So even if it was wrong and didn't necessarily follow this accountant's accounting procedures, we relied on our experts, and that's all we have to do. And the circuit court said, I agree. I don't know that I like the look of this budget or the numbers on it, but pretty clearly you relied on experts, and so board, you're protected. So that war story aside, that's generally how it works. If I can go to court and show a judge that the board relied on their experts and in doing so acted reasonably, the board is generally protected from claims against you, the individual board members. So we're talking beyond, just a claim against your association. This is where a member attacks you, the individual board member, for a decision you might have made as a board member. Now, there are other protections in place like directors and officers insurance, which I think Craig is going to bring up here in a moment. But a big one is the business judgment rule. Rely on experts, and as has been the theme, I think, throughout this afternoon, consult with all of your experts, have that documented, and that's your best protection moving forward, especially when we're dealing with something like this COVID-19 pandemic. We're in uncharted waters, and so the board's going to have to go out on a limb, maybe in some cases, to make some decisions. So make sure that background is in place where you can show, if you ever have to, we did our due diligence, we consulted with all of these experts, and then our decision is protected and deemed reasonable.
Well, if the doctrine is one of your best friends, I would recommend you expand your friend network, but that's for another day.
That's fair. That is fair.
Monique,
It's fair, and Craig, you don't know how accurate that actually is.
Monique, talk about the documents and whether they provide me any comfort as a board, and then maybe the statute. How am I protected, as a board member by those two doctrines or those two pieces of legislation?
Sure. All three acts, the Condominium Act, the Homeowner Association Act, the Cooperative Act, and also Chapter 617 of the Florida statutes contain provisions that we generally loosely refer to as indemnification provisions. And essentially what it says is if the board is acting in good faith and reasonably in the manner that a reasonably prudent person would act, and as Adam said, relying on the advice of experts, then they're going to be protected. The law will actually protect them as well as their insurance. So it's all throughout the statutes. And if that weren't enough, I would say 99% of time, it's also going to be in your governing documents, typically in the Articles of Incorporation. There'll be an indemnification provision that also protects the board for, mistakes, bad decisions, even negligence sometimes. Even if you were blatantly negligent, sometimes there's still an indemnification provision in there that will protect you, provided you're not acting recklessly or with self-dealing. Those are the big things. You can't be reckless, you can't act with self-dealing, and it gets back to exactly what Adam says, relying on the advice of experts and acting in the manner that a reasonable person would act under the same or similar circumstances. That's what's going to protect you. If you don't have that provision in your governing documents, you should have it in there. But again, you can fall back on the statute. So there's a lot of protection in place for the boards. With one thing, I will have to say, notwithstanding the existence of those provisions, you have to understand that anybody can sue anybody at any time for anything. That's the whole access to the courts provision, right? So what happens is, even though those protections are there and in place, it doesn't necessarily insulate you from a lawsuit. You can still be sued. It's just that there are mechanisms to protect you if that does happen, where we may be able to have it dismissed, and if we can't have it dismissed, at a minimum, we can get some protection from the association's insurance for the board. But you still have to be very, very careful to avoid even getting sued.
Adam, we're winding down. A quick comment on directors and officers insurance. How does that help me as a board member?
Yeah, very quickly. One, make sure you have it. Two, directors and officers insurance protects the individual board members if you're sued in your capacity as an agent or an officer of the association, where you're acting in your capacity as such. So if you branch out and you're pocketing money, it's not going to protect you. But if you're sued when acting within your capacity as a director, so when you're making these tough decisions during COVID as it relates to whether or not to secure a loan and how to handle funding and how to handle guests coming into the property, and a board member or a member of the community challenges that decision, alleges breach of fiduciary duty, as Monique said, sometimes negligence will be covered. Your directors and officers policy should kick in. And primarily where we see the most benefit to that directors and officers policy is those policies contain a duty to defend on behalf of the insurance carrier. And that means the carrier has to, if it's a covered claim, appoint defense counsel to represent you, the individual board members, at no cost to the association above and beyond the deductible. So instead of paying your general counsel an hourly rate, you'll have defense counsel appointed to defend you, the individual directors, for those legal fees. And that's the substantial portion of the costs incurred, or the legal fees to defend against that claim. So that's where the directors and officers policy is very important.
That's fantastic. And what we have learned is there's some very distinct directors and officers policies. So I highly recommend you get with your insurance company and understand the exclusions and what's covered and what's not. As we wind down, there was one follow-up question in regard to the ballots and the annual meeting, and it's very specific to, can I hold the meeting? I would suggest that the participant who's asking that question really just call their attorney. I think there's Monique pointed out, there is a way to make it happen, so I would just get with your specific counsel. Monique and Adam, I wanted to thank you. Let me just quickly go through what we covered today. Where we are, you gave us some great guidance. We're kind of waiting for the shoe to fall on the other side of this at this point, and hopefully the relaxing of these rules that we have in place. And I know we're planning for that at Castle and anxiously awaiting it. We talked about collections, business as usual, mostly to protect the association as we go down the road here and be in a position when everything turns around to collect your maintenance, because we don't have a problem in an association if our maintenance is collected. Talked a little bit about cash, do an inventory of where you are, figure out what resources that you have from a cash standpoint. There are certain circumstances you can borrow from reserves, get an emergency line of credit with your banking partner, Basically, associations are good credit risk. So unless you're unique, the likelihood that your bank will provide you an emergency line of credit is a good one. We talked about securing those with special assessments. We talked a little bit about meetings. Have them. There is business to be conducted. There are tools in place, Zoom being one of them, to have remote meetings, practice social distancing. Great discussion on the liability insurance, the business judgment rule. Talk to your professionals. Don't go down the road on this yourself. You have management company, you have your CPA, you have your attorneys, you have your insurance agents. Talk to those people. So Monique and Adam, thank you again for joining me this afternoon. Adam, any final words before wisdom before we sign off here this afternoon?
No, this is all going to come to an end at some point, so we're all going to make it to the other side of this thing. We'll hang in there and get through it together. Thanks very much for having us, Craig.
My pleasure. Monique, anything to add?
No, other than stay safe, and when the amenities start to come back online and the restrictions are lifted, just be careful. Try to make sure that your common areas are all very sanitized and clean, and don't relax your standards right away, because yes, everything is going to get better, but it's going to take some time, and everybody's going to have to be smart, even when the stay-at-home orders are lifted, even when we're able to start meeting again. You really still need to be careful and take things slowly and use due diligence to make sure that you keep everybody safe.
That's great. In fact, my partner next week is doing a webinar specifically on, what is your plan for reopening? We can't do it right now, but we're going to be opening, so what does it look like? Well, listen, everybody who's been participants, thank you for tuning into today's webinar. If you have any additional questions, please feel free to submit them to info@castlegroup.com. Certainly, I won't be able to answer a lot, but I'll make sure they get to Monique and Adam, and they can provide the real legal guidance. Please follow us on social media. I would like to thank everybody again this afternoon. Have a safe and healthy weekend, and we'll ride this all out together. So thanks again, everybody.
Thank you.
Thanks all.
Have a great day.
Take care.
Bye-bye.
Take care. Bye-bye.